Mr. Arsenault, you are charged with interference with the emergency request for assistance. You are facing up to a year in jail and or a $4,000 fine. It seems that probable cause has already been found in this case.
Yes, sir, Judge. I don't know why we're here, but,
Because he bonded out.
Oh, yes,
He's
sir.
been, I guess he's been AWOL, right?
No, sir, he's been in custody, Judge. He was, he had a felony, assault of a family member that was dismissed, last week,
Okay.
and that's why he got out.
All right. So are there any kind of bond conditions that you guys would like state?
So for this one, just standard conditions would be fine with this type of case. And there's no contact for this.
Who's the complaining witness in the
Whoa, hold up, did you catch that? The alleged victim is the defendant's mother, and she's now asking for the charges to be dropped? Family drama in the courtroom always raises the stakes. But here's the twist: just because she's backing off doesn't mean the state will. Why do you think prosecutors might keep going anyway? Sound off in the comments.
No contact for this.
Who's the complaining witness in the
His mother, Judge.
His mother, judge.
okay. Is that the complaining witness that was in the felony as well?
That's correct, Your Honor.
Okay. So I'm ordering you not to have contact with this person. Do you understand?
Judge, if I may, I provided the state with some information relative to that. The complaining witness in this case is not willing to go forward. She provided a letter to me, which I have already given to the state. She's requesting that the case be dismissed.
The state would not be opposed to no threatening or harassing contact at this time. And just give us another date to reset to look at the 911 phone calls to make sure that.
Okay, so the case is 180 days old. It's time. So I'll give
Okay.
you a week.
Yes, Judge.
So I'm ordering you not to have any threatening or harassing contact with the complaining witness in this case and not to be in possession of weapons. If I find that you violate these conditions, I'm going to revoke your bond, put you in jail. Do you understand? I'm not asking for much. Now, your case is old. It's time to figure out what we're going to do. So I'm going to give the state a week to get everything done, wrapped up. They're going to put an offer on the case. The next time we come back, you must either accept the offer or I'm going to set your case for trial. Do you understand?
Yes, sir.
Okay. So do you mind filing those conditions, please?
Yes, judge.
All right. We're going to have you sign the conditions. After that, we'll see you in a week. We'll go from
Thank
there.
you, Your Honor.
Okay. Thank you, Mr. D.
Yes, sir.
You are not allowed to drive. Do you understand? If I find that you pick up a new case or another third case, I'm going to go nuts on all of the bonds. I'm also going to test you 45 to 50 days from today. You're not to use marijuana at all. Do you understand? If I find that next time I test you and you test positive, it's just not going to go well for you. You understand? We've given you a lawyer. There's just no more excuse. If you get your license and insurance, Mr. Jackson, I will happily take this restriction off. All I'm asking you to do is follow the law. I'm not asking you to split the atom here. Really.
And Judge, we're working on it. We have a out-of-state fine or suspension, but we cannot figure out what state it comes from at the moment. So we
Call
are working.
DPS, you know.
Yeah. Because they're even
You
when they
can
run.
call DPS. Have I given you the phone number?
I don't think so, but
Hold on.
I think it's in Jacksonville.
Do you mind giving this to me? This is the number to the driver's license division for DPS. When you call, you have to call at 7 o'clock in the morning. Do not call at 8. Do not call at 9, 102, because you'll never get through. Right when the phone line's open, call them. All you have to do is ask them, what do I need to do to be able to get my license? And then they'll tell you. All right, I'm going to have you come up here, promise to us that you're not going to drive. Then I'll get you to Victoria Sign and Reset. You'll get with Felicia if your bond conditions, and after that, you're ready to go. All right, good luck, guys. You got it. Ms. Johnson, you're charged with making a false report to a police officer. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, man.
Yes, judge. On January 19th, 2025, at approximately 1:56 p.m., the officer was dispatched to a child custody dispute at a residence in Harris County, Texas. The officer made contact with the defendant's husband, who requested a report be completed because the defendant did not meet him at a scheduled time and location. The officer made contact with the defendant at 4:45 p.m. via the phone, and the defendant was advised about the husband's request for a report. The defendant became upset and stated she was going to call the defendant's probation officer and say what she needed to say to get his probation revoked and serve 2 to 10 years in prison. The defendant stated she had video footage of the husband assaulting her last month on the phone, and she was going to call and have a deputy come to the residence to pursue charges because he completed the report. At approximately 5:37 p.m., the defendant made a family assault call, and the call slip stated, "See reportee," in reference to husband cussing and pushed.
This is the kind of moment courtroom junkies live for, a full incredibility crash. Multiple versions of the same story, denial, backpedaling, and finally boom, the body cam footage calls her out. Ever wonder what happens when someone lies during an investigation? This right here is textbook. Would you trust any claim after that flip-flop?
Reportee. The officer, who had previously contacted the defendant, arrived at the family assault call at approximately 6:02 p.m. and made contact with the defendant. The defendant stated the husband pushed her on 2 separate occasions in January 2025, and the defendant then stated the husband did not punch or push her, he merely brushed against her and admitted it was not intentional. The officer asked to see the video the defendant stated she had. The defendant denied making that statement, and the defendant then admitted to making the statement and stated she did not have a video, but the daughter was present. The defendant stated she did not feel pain, did not have visible injuries, and wanted to pursue charges. The defendant then attempted to change statements again, stating she never made a call for service. The officer read the call slip, and the defendant stated dispatch did not hear her correctly, and that was not what she meant to say. The defendant further denied making a statement regarding the husband's probation. The officer replayed a body-worn camera video of the defendant's statement while on the phone, and the defendant admitted she was not telling the truth.
I never admitted it.
All right, ma'am, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to have any contact with the complaining witness in this case. Do you understand? That is the gentleman in this case. If I find that you have contact with this person, I'm going to revoke your bond. Look, I can provide you a lawyer today. You can explain your side to the lawyer, but I've got a bunch of DAs here. Anything you say, they're going to try to use it against you to prove guilt. Just don't. I will give you a lawyer. Just explain your side to the lawyer, and then they can go talk to the DAs on your behalf. But I don't want you to say something where you put your proverbial foot in your mouth, you know? Don't. Just. So what I'm going to do is I'm going to have you sign a receipt of Victoria. I will have you then take a seat in the jury box. I'm going to find you a lawyer, and then you can explain your side to the lawyer. Okay? Let me see one thing real quick. I need you to fill an application for me, though. Do you mind? She's going to give you an application. I need you to fill it out, and then I'll have you talk to someone here momentarily. No. Ms. Prejean, you are charged with aggregate theft. You are facing up to a year in jail and/or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
Yes, Judge. The officer met with the complainant, the Walmart Asset Protection employee, and the complainant stated that he reviewed store surveillance, and on September 12, 2023, the complainant observed the defendant open the register multiple times, take cash, and place the cash into pocket, a total of $790.41. On September 13, 2023, the officer observed the defendant conduct a fraudulent return for a total of $60.02, and on September 18, 2023, the complainant observed another fraudulent return by the defendant for a total of $101.77. On September 20, 2023, the complainant observed the defendant process a fraudulent return, take money from the register, and conduct a fraudulent return to obtain a gift card following the transaction for a total of $120.64. The complainant stated the defendant did not have permission to take money and desired prosecution. The officer made contact with the defendant, who admitted to stealing from the business 4 times, with each time being $200.
All right, ma'am, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to go to any Walmart for any reason. Do you understand? If I find that you go to Walmart, then I'm going to revoke your bond. I'm going to put you in jail. Did you need a lawyer, ma'am? Okay, I'll appoint you one today. I'm going to have you sign a receipt, Victoria, then we'll have you take a seat in the jury box while we find your lawyer, ma'am. Ma'am, you were charged with assault. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
Yes, Judge. On January 20th, 2025, the officer arrived at the complainant's apartment due to a disturbance call, and the complainant asked the defendant to leave her apartment after a verbal argument. The child was present, and the defendant then pushed the complainant, leading to further argument. The defendant danced at the complainant, landed at least one with her right hand, which were also holding a pair of keys. The keys scratched the complainant's face, leaving red marks. The complainant then held the defendant on the floor to stop her from punching her until she calmed down, at which time the defendant proceeded to spit in the complainant's face. The complainant then let the defendant up and told her to leave. The complainant stated her pain level was about a 3 out of 10, and the officer observed the complainant to have 2 red scratches on her cheek.
This is the complaining witness to Mr. Price, please.
Your Honor, the complaining witness is mother of the grandchild, mother of her grandson.
Ms. Price, I'm going to find that there's probable cause to go forward with your case, and I'm ordering you not to have contact with this person. I'm also ordering you not to be in possession of any weapons as well. Did you need a lawyer today? Ma'am? Okay, I will appoint you a lawyer. For now, I'll have you sign a receipt. Victoria will have you take your seat in the jury box. Do not leave until you sign our bond conditions, then I'll have you speak to the lawyer here. Okay, please. Okay, ma'am, you're charged with driving while intoxicated. Second offense. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Yes, Judge. On January 20th, 2025, the officer, a certified DRE, was dispatched to the scene of a wreck at a parking lot in Harris County, Texas. The defendant had been refused entry to a bar at the location due to appearing visibly drunk by the staff. A witness stated the defendant was not walking straight and had a hard time standing. The officer observed the defendant trying to back up from the scene of the wreck when he made a stop. The defendant had watery eyes, a strong odor of alcoholic beverage, and furthermore, the defendant was not making any sense when describing what had transpired to the officers. The defendant was transported to Pasadena jail, where Miranda was read and SFSTs were performed. HGN 6 out of 6. Walk and turn. The defendant took 15 steps instead of 9 and missed every heel to toe. In the one leg stand, the defendant used arms and swayed. The DIC was read and the defendant consented to breath. The results were .212 and .217.
And Ms. Tovar Martinez, I'm going to find that there's probable cause to go forward with your case. Do you see if she has a valid license, please?
I'll run it right now.
I am now placing a restriction on your license, ma'am. You are not allowed to drive any vehicle that doesn't have an ignition interlock on it. If I find that you drive a vehicle that doesn't have one, I'm going to revoke your bond, put you in jail. No more PR bonds. I am also ordering you not to consume alcohol or illegal.
And just like that, the judge goes full accountability mode. No license, no driving. And now every cop in the state will know it. That handheld breathalyzer is her new best friend or worst enemy. Question for you, should judges come down harder on repeat DWI offenders like this, or does this go too far?
Drugs, and I'm going to randomly test you. If I find that you're using anything illegal, likewise, you will go to jail. No more PR bonds for you, ma'am.
Your Honor, we have no license on file.
You do not have a license, then no driving. Do you understand? You will be signing an affidavit with me today, promising you're not going to drive, and I don't care what is going on in your life. Do not drive. Since I'm ordering you not to drive, you will get a handheld interlock device that you're going to take with you everywhere you go to prove to us that you're not consuming alcohol, ma'am. I'm sending notice to DPS in Austin that every single officer in the state will know that if you get pulled over, you're supposed to have an interlock in your car. So if you're caught driving a vehicle that doesn't have one, they're going to put you in jail. Do you understand? Would you like a lawyer today, ma'am? Okay, so for now, what I'm going to do is I'm going to have you go to Victoria, sign a reset. You will get with Felicia for bond conditions, and then I'll have you take a seat in the jury box while we try to find you a lawyer, ma'am. Okay. Morning, Mr. Daniels. Do you have a lawyer today?
Sorry.
You want to apply for a court-appointed lawyer?
I just started working. I'm gonna give I know I was just a second.
All right, put that seat in the jury.
I'll have a lawyer next quarter.
I'm willing to give you a free one. Okay, it's up to you. If you have any problems, come back.
I just started working, so I'm saying,
Good job, man. Great. What are you doing?
delivery, so. Third parties,
Get a trade, dude. Get a trade. Go like welding or something like this.
I got my forklift, it's hard finding jobs, it's hard, so I knew somebody that got me in with the delivery, so.
Good.
Yeah.
You know, the better you do, the higher you're going to go. Anything in life, man. Put your heart into it. Your sky's the limit. Right. Okay. THA. All right. We got you, man.
Thank you.
Good luck. So, ma'am, it looks like your lawyer was involved in an accident this morning, so he's not going to be here. So what we'll do is we're going to do probable cause. After that, we'll just give you a normal reset. They called us to advise you to call the office, and then you guys can get together with them. Okay. So, ma'am, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. On January 19th, 2025, the officer was dispatched to a Target in regard to a theft. The officer made contact with the complainant, a loss prevention employee, who stated she observed the defendant walking inside the store, grab a shopping cart, select numerous items, place the items inside the basket, and conceal cosmetic items, food, and office items inside her purse. The defendant headed to the register where she only paid for the items in her basket before exiting the store and passing all points of sale. The total was $111.28.
All right, Ms. Saldana, I'm going to find that there's probable cause to go forward with your case. Where is this from again?
Target.
Target. I'm ordering you as a condition of your bond. Target. Do you understand?
Yes.
If you violate this condition or if you pick up a new case, a warrant for your arrest will be issued. No more PR bonds, ma'am. So can you file that, please?
Yes, Judge.
I'm going to have you sign a reset. We'll have you take a seat in the jury box while I get your bond conditions. We'll have you sign it, and after that, you'll be free to go. Okay? So Danuno was in an accident this morning, I guess, so he's not going to be here. So we'll just do a regular reset, just do, I guess, 30, 45 days. And then she needs state's conditions. How are you?
Good, how are you, sir?
Happy Monday.
I'm sorry, I couldn't hear you.
Happy Monday.
Oh, happy Monday.
I have one of our trial cases for tomorrow.
I believe I have one set, but I think he pled his felony.
It's Mendoza.
Yeah, I think he pled his felony, and if not, I will announce not ready, mostly because I got texted some videos last night. Well, I got emailed some videos last night.
Let me pull them up real quick. Hold on.
I feel like he was dismissal if he pled the felony, and then I think they rushed the felony.
Judge, do you have the case number?
I do.
Okay.
2502-101
And 02.
and 02. They reset it.
I don't see it.
219.
No. My
Yes.
problem is I have they all overlap, and I swear I have two reckless drivings, each of them with a gun, and one of them called my office to say he pled. I guess it might have been the other one.
Our gun case pled, but the reckless driving is still open.
Okay. Now,
And then it looks like the felony evading in a vehicle got reset to 219.
all right, can we hold off on that till tomorrow, Judge? Because I came in here thinking that they had pled upstairs. And I obviously got the guy confused who pled upstairs. So let me make some phone calls. Because a client called me to say that he had pled. And I thought it was this one.
What are they doing upstairs? Is there any news?
We're in touch with defense upstairs and they are gonna the defendant is gonna take the deferred and felony and then dismiss our cases, adding the condition about the firearm, I believe.
Yeah,
They're doing a
gonna force-
TRAS? Is that why they did the reset? Are they doing a TRAS upstairs? Is that why they did the reset? Because a lot of times prior to a plea, they'll do a TRAS.
You reset from the last setting without actually agreeing to plea. Kelsey then sent out the email, hey, will you do it? They agreed to plea. I thought my client called me to tell me that he had done the plea. I think he has now agreed.
Did they do the
to
thing
do the
maybe?
plea.
And they just set it to do a TRAS?
They hadn't officially done it yet, sir, but I'm talking to the felony defense counsel, and we were hoping he could just come do it tomorrow when this one's set for trial, but we wouldn't actually be going on it because that was the agreement.
Bless you, whoever you are.
Is he in custody?
No, he's not.
I'm looking at I'm just looking at.
I will say, I got the cell phone video that was emailed to me yesterday, and it's not particularly reckless. Yeah, the donuts, there's a good distance between him and all the other cars. Shush.
On the reset, they didn't mark anything. And then under settings, it's just a non-trial setting.
Well, so they reset it, and then after they reset it, Kelsey, and I'll give all the credit to Kelsey, sent all the emails and got everybody to agree to take the plea. So all the paperwork was before the defendant had agreed to take the plea.
You said you want to set it for tomorrow?
No. I thought he had already taken it, and I think we're set tomorrow.
Right.
So I can have the
Want to go
client come
ahead
in
and
we
set
can-
it?
Well, I
To,
can walk him up to felony court, except for the fact that I'm not his felony lawyer, so I can't take the plea.
I'm not asking you to do
No,
that.
what I was saying is I
Set
could
it
normally do
after
that.
the felony.
Oh, yes, please. But I would say leave it for tomorrow, because I don't want to communicate with the client. Like, if he's not set tomorrow, I might not be able to get a hold of him, and he might come in anyway. So if we leave it
Good on
tomorrow,
it.
he comes in, I say hello, and then I set it for the day after the felony.
So what if he doesn't show?
Tomorrow? Oh, cup tin of beans?
So I revoke it?
I would hope not, but that's a conversation I'll reserve for tomorrow.
I mean, what's, okay.
Yeah. You're thinking two steps ahead, but like kind of in a lateral direction as well.
Have to.
I know, but right now we have a resolution, it's plotted out, we're gonna get this resolved.
With you.
I'm choosing to think positive. Also, I'm trying to suck up to this one because I need a time served offer on a different case.
Okay.
All right, thank you, judges.